Hello again, everybody. We're here with Toronto-based divorce lawyer Timothy Kinnaird, who's going to be sharing with us today some of his expertise when it comes to divorce and separation agreements. Timothy, can you please explain to our viewers what a separation agreement is?
The law recognizes what are called domestic contracts. There are three types of domestic contracts. The first are those cohabitation agreements for those living unmarried with each other. There's prenuptial agreements or marriage contracts for those intent on marriage. And separation agreements, which is the subject of this video, for those splitting up and wanting to settle all the custody, support, and property issues arising from the breakdown of their domestic relationship, whether married or common law. Now, in terms of common law, if you've lived with someone for 3 years or more in some provinces, you are deemed by the law to be a common law spouse of that person. And all of the issues regarding custody and support, not property, but just custody and support, are still relevant to unmarried but separating common law spouses.
So what specifically is a separation agreement then?
A separation agreement specifically, Dee Dee, is a domestic contract which can set out the terms of any agreement the parties have reached regarding the following, essentially custody of the children, their support and who pays, spousal support from one to the other, defining how much and for how long the spouse will be paid, and if there are any properties, who gets what, when, and how much. Essentially, it's a written agreement setting out all the issues arising from the breakdown of a domestic relationship, both a marriage and a common law one. It can be enforced by registering it with a provincial government agency for support payments and can be turned into a court order for other matters.
Do I have to have a separation agreement before I can get a divorce?
You do not need a separation agreement, but it is highly recommended. Ideally, what you should have as a minimum is something in writing that confirms a date you have both agreed to legally separate. According to the law, you must be living separate and apart for 1 year in order to file for a divorce. Now, some think you have to move out in order to be living separate and apart, but many couples simply can't afford to maintain two separate residences, especially if there are children involved, while they sort out their finances. Now, also, as a minimum, if there are children, in order to get your divorce, you must have something in writing confirming who pays their support and how much before the courts will grant you a divorce. But for all other matters, you do not need a fully comprehensive separation agreement to get a divorce.
So from what you've said, Timothy, it sounds really necessary that couples have a valid separation agreement. Can you comment on this?
There is a very high risk that if you and your partner draw up something informal, a written memo detailing what each thinks is the final settlement of their financial affairs, it may prove to be defective in some legal way. Therefore, it would be unenforceable, and it would leave you with no way of compelling the other to pay up what was agreed to. So, if your informal agreement is found to be unenforceable regarding, let's say, child support, your divorce application may very well be rejected by the courts, making you start the whole process all over.
What is the best way to settle all the issues arising from my divorce so I can finally move on with my new life?
Well, Dee Dee, I can tell you what the worst way is, and that's going to court and litigating when nothing gets settled for months, if not years, and there may be nothing left or much to share at the end except perhaps lawyers' bills. A private agreement rather than a public fight between the parties is always the best way to go.
And what about our property and assets?
Well, for those things, for a married couple, a separation agreement will lay out the amounts and the timetable for the sale or buyout of family property and a final accounting of all the assets. Now, on the other hand, generally unmarried or common law spouses do not get to share in the other's property. The exception to this is that if a couple has been together for an extended period of time and they've joined up in many business ventures, or perhaps one is taking care of the kids while the other's out making money, claims for a sharing of the property of the other may be made out. These claims are somewhat complicated, and the assistance of one of our lawyers is strongly recommended in these situations. So I would like to invite our viewers to watch the video we prepared on divorce as it pertains to the family home, and the sharing of properties and assets that a family has acquired during the marriage if they want more specific information.
How do I go about getting a separation agreement? Do I need a lawyer, or is this something I can draft up on my own?
Technically, you don't need a lawyer, but as I mentioned earlier on, there's a very, very high risk that if you and your partner draw up an informal written memo detailing what each thinks is the settlement, it may prove to be defective, and you will have wasted precious time and money fixing the mistakes, and will have to, in the end, pay for a separation agreement anyways. And this may all cost you way more than the money you would have spent having a proper separation agreement drawn up that will stand up in court. And I can tell you that it would be disastrous to think that you have a valid agreement only to find out after the limitation period for making a claim for your share of the family property has expired, and then you and your children will end up literally left with nothing.
If we can come to an agreement, can my spouse and I use one lawyer to save money?
A lawyer can only represent and give advice to one party. You can both agree to share the cost of one lawyer for drafting up the agreement, which will formalize your understanding of the settlement. Now, Dee Dee, at least one lawyer will be involved in putting on paper what is instructed by his client about what the deal is between the two parties. It is up to the other to seek independent legal advice and then accept the draft agreement as accurate or not. So if it's your spouse who puts a draft agreement in front of you, you in turn will absolutely need to have it reviewed by your own lawyer. To make this agreement final, both parties must obtain a certificate of legal advice, which are then attached to the agreement. Now, we provide certificates of legal advice after a review if your spouse has put in front of you a draft agreement for your signature. But be very careful about signing any such agreement without a lawyer to review it. You could really hurt yourself and your children financially by being rushed or pressured into signing something you may not fully understand. Call me. I am always available to review any agreement and properly advise you as to its fairness and give you a certificate of legal advice.
What first steps can I take in getting a separation agreement?
Well, I strongly advise our viewers that in order to make this process the least expensive, that they sit down with their former spouses and set out on paper exactly what they think is a fair and equitable settlement of their financial responsibilities, which they owe to each other. One party should take that paper memo to a lawyer who will then put those terms into a legally binding agreement.
Is that all I need to get a separation agreement drawn up?
Well, the lawyer will usually require the both of you to make full financial disclosure so that each is aware of what they are gaining or losing before the agreement is even drafted. If there is a lot of property or where valuations may be required, sworn financial statements from each may be necessary to make sure nobody is hiding anything. Now, if someone is hiding something and subsequently it's discovered, a court may very well tear up that agreement and make the parties start all over again.
So once financial disclosure is made to and from my ex-spouse and we're all satisfied with the numbers, what's next?
After financial disclosure and after your lawyer has drafted an agreement, you would then take that draft agreement and give it to your ex-spouse. He or she will probably be told that they need to see an independent lawyer, but they can also refuse to see one. Now, after a brief review of both the agreement and the financial disclosure with a lawyer, that will make the agreement all the more binding. And that lawyer will certainly make sure that it complies with his or her client's understanding of the agreement that's been reached between the parties. The other lawyer will then execute what is called a certificate of independent legal advice that we mentioned earlier. This certifies that the party has been fully advised of his or her rights and obligations under the law regarding their separation, and that each has signed it without any compulsion or duress from the other party. Now, these certificates are attached to the agreement by both parties' lawyers to ensure that the agreement is even more enforceable. Now, your viewers can contact me to either draft such an agreement or review one given by your ex-spouse, for which I can provide a certificate of legal advice. So I'm available at the link below.
Tim, Can't getting another lawyer involved sometimes incite the two parties by blowing up the issues and then having it lead to that dreaded litigation that you warned us about earlier?
Well, it shouldn't if it accurately reflects the agreement of the parties and they both stay fair, reasonable, and realistic. Keep your emotions out of it and do use a third party when necessary as a mediator rather than another lawyer if indeed a dispute does break out.
Based on your experience in family law and divorce, Timothy, is there any additional advice you have for our viewers today?
As I've cautioned in our other videos, time is the enemy, and if you wait and wait before proceeding into a court, things may change for the worse, making it much harder to come to an amicable and fair agreement about the children and the money. Now, things can happen in life which can wipe out the family property. A stock market crash, a personal bankruptcy, or as I have seen, Revenue Canada swoops in and takes everything. Just imagine the worst case scenario, and there is likely a good chance, if things are left to drag out, that it will probably happen. What's worse is how time flies as you get caught up in your new life and you fail to act within the 2 years of the divorce judgment or 6 years after separation. You may lose your fair share of all the family property you worked so hard to acquire during your marriage. If you've been living separate and apart for a year, act fast. Act now before a sudden change that may prevent what should be an easy, cheap, and uncontested online divorce. If you can do it now. I invite our viewers to contact us for further information regarding these separation agreements, which are always a far, far cheaper way of resolving all of those remaining issues you may have left unsettled after getting your divorce online than going to court.
Thanks once again, Tim, for sharing your expertise and knowledge with our viewing audience.